pleased to say that I have long since seen the error of my ways, and there are none more devout than the converted. So much so that I now find myself following one of the recognised entry routes for a career as an international arbitrator, namely full-time on-the-job training of indefinite duration as a judge of the commercial court. Now, the topic of arbitration and the rule of law has attracted contributions from some very distinguished speakers indeed. Notable amongst the common law contributions would be Lord Hoffman's paper, Lord Neuberger, and Chief Justice Sundaresh Menon in Singapore. And those speeches they have given offer valuable insights into how different conceptions of the rule of law apply to the resolution of disputes by arbitration. And they have a very interesting debate as how far the Bingham iterations of the rule of law are germane to and realised by international arbitration. Now, you will all be pleased to hear that in the 2:15 graveyard slot, I will not be subjecting you to a bantamweight contribution to that heavyweight debate. But I do regret the loss of the opportunity to pose Tony Hancock's question about what many regard as the historical origin of the rule of law in this jurisdiction. Does Magna Carta mean nothing to you? Did she die in vain? Now, fortunately, the organisers of the conference have allowed for the fact that I'm only 4 years into my period of indefinite on-the-job training, and therefore have entitled this slot The Role of the Court. And what I want to do with the benefit of that prompt is consider 3 of the areas in which the commercial court engages with international arbitration, and how in different ways that engagement may reflect the rule of law. The first of those areas I have called patrolling the arbitral perimeter. Sometimes we build walls to keep people out, sometimes to keep them in. There's been another conference this week that's been rather more focused on the first of those two, but the commercial court undertakes both. Our function in containment is intended to ensure that the promise to arbitrate is kept when one of the parties thinks better of their original decision and seeks to bring proceedings in a court. Now, that is a function we most obviously perform when we stay proceedings brought in our jurisdiction, where they, to the extent they concern a matter which the parties have agreed to refer to arbitration. That is, I think, one of the few occasions when specific performance of a non-monetary obligation is mandatory. And what's more, it's mandatory regardless of the applicable law of the arbitration agreement, provided there has been an agreement to refer the dispute to arbitration. Now, for reasons of comity, the other principal means by which the commercial court secures this side of the arbitral perimeter is not mandatory, the anti-suit injunction. But I suspect those who have sought or tried to resist them will have detected that if the first element of the applicable test is satisfied, a high degree of probability that the arbitration agreement governs the dispute referred to the foreign court, it is a rare case indeed in which the injunction is refused, either because there are strong grounds for refusing relief or because it would not be just and convenient to grant the injunction. I suspect, short of cases where the dispute in the foreign court has, with the active concurrence of the party seeking the injunction, proceeded quite some way down the path, you will find very few cases indeed in which an anti-suit application fails at the second test. Now, whilst the court's role in patrolling that part of the arbitral perimeter undoubtedly has an ethical underpinning, it does not obviously give effect to the rule of law. The ability of parties to agree the means by which their disputes will be determined reflects the values of personal liberty or autonomy, the freedom to make choices and take action subject only to limited constraints where they're necessary for the proper functioning of society. The enforcement of agreements reflects the moral imperative of holding people to their promises, pacta sunt servanda. Now, one might, I suppose, say that in giving effect to those values, the court is supporting the fifth iteration of Lord Bingham's formulation of the rule of law, affording protection to fundamental human rights. But it is in the assertion that the rule of law has that substantive content that it has proved most controversial. And in any event, if that is giving effect to the rule of law, then that is also true of every part of the law of contract, rather than anything specific to the law of arbitration. Now, what of the second aspect of the court's role in performing the arbitral perimeter, the exclusionary role, ensuring that those who have not agreed to submit a particular dispute to arbitration do not find it determined there nonetheless? Now, we exercise that patrolling function, of course, when we refuse to stay proceedings brought in our court because we determine that the requirements of Section 9 are not satisfied, the parties have not agreed or entered into a binding agreement to refer a dispute to arbitration, or that agreement is null, void, inoperative, or incapable of being performed. When we refuse to enforce an arbitration award under Section 66 or Section 103 on the grounds that the tribunal didn't have jurisdiction, and when we uphold challenges to arbitral awards under Section 67 of the 1996 Act on the basis that the award was made without jurisdiction on the tribunal's part. Now, that exclusionary rule, which I am conscious in the present company is perhaps more controversial than our role in holding parties to arbitration, can be said to support the rule of law, I think, in two ways. First, I think it's a more convincing application of Bingham 5 because it reflects the fundamental human right of access to a fair and public hearing by a tribunal enshrined by law. A human right you will find in most statements of human rights, including, of course, Article 6 of the European Convention. It also reflects the fact that within the arbitral perimeter, there is an attenuated application of other aspects of the rule of law. This is the case for Lord Bingham's seventh aspect, that the adjudicative process will be fair. The threshold for interference in an arbitration on grounds of procedural irregularity is very tightly confined by Section 68. It can be lost altogether by failure to object in time in the arbitration or by delay in bringing a court challenge afterwards. It also arguably the case that Lord Bingham's sixth aspect, resolution of disputes without prohibitive cost or inordinate delay, is engaged. To the extent to which an arbitrating party has related claims against third parties to the arbitration agreement and faces the risk of trying a dispute twice with potentially different outcomes because part of the dispute is subject to an arbitration agreement and part is not. Now, it is critically the consent of the parties to the arbitration agreement which justify accommodating what might otherwise be seen to be derogations from the rule of law in the court sense. And that makes it essential that in the exercise of its patrolling power, the court ensures that that attenuated version of the rule of law only applies to those who have properly signed up to it. Now, there have been persistent calls in some quarters for the commercial court to reduce the intensity of its perimeter patrols so far as the exclusionary aspects of the arbitral perimeter is concerned. It's said that we should adopt the prima facie standard of review when determining whether court proceedings should be stayed, when many other trial model law jurisdictions do that, Singapore and Hong Kong. And it's been suggested we should adopt a review rather than rehearing approach when determining jurisdictional challenges under Section 67 of the Arbitration Act. In each case, the justification given is that Section 30 recognises the power of an arbitral tribunal, at least on a presumptive or preliminary basis, to determine its own jurisdiction, competens. The court should facilitate that at the stay stage by staying proceedings without deciding whether there is an arbitration agreement or not if the prima facie standard is met, and by having a lighter touch review at the post-award stage because the arbitrators have already looked at the matter once. Now, on both of those questions, I favour maintaining English law as currently formulated, but I think there is scope for making more extensive use of procedural controls to prevent the misuse of those processes. A starting point for me is that if someone is to have their Article 6 right in its fullest sense abrogated, then they must have agreed to do so. I acknowledge that the prima facie standard allows a party to come back and argue the point again at the Section 67 stage, but in the interim they will have incurred the expense of fighting an arbitration under a reservation before a tribunal whose jurisdiction they do not accept. It is a brave thing indeed to stand aside altogether and run your strategy purely on the Section 72 challenge available to those who don't take part in an arbitration proceedings. Your time for bringing your Section 67 challenge is limited, and it can require you to incur significant expense to be in a position to bring the challenge ex post facto. The other point that always interests me in this debate is you'd be surprised how many people both support changing Section 9 to a prima facie review on the basis that the Section 67 challenge at the end of the day will preserve the importance of the agreement to arbitrate, and support reducing the scope of the Section 67 challenge to review of the arbitrator's decisions on the basis that Section 30 means the arbitrator has already looked into it. Now, the principal argument in favour of Section 9 reform, and it is an argument of substance, is that there will be many cases in which determining the Section 9 issue at the outset wholly in favour of the party seeking the stay or resisting it will effectively have determined the substance of the dispute which the parties have agreed to arbitrate. At the moment, if the court is virtually certain, to quote one case, there is an arbitration agreement, or it's agreed there is one, but the dispute is as to its scope, the court can use its case management powers to grant a discretionary stay of court proceedings until the arbitration is concluded. To date, at least, the courts have rather set their face against the use of that case management stay power, save in particularly clear and exceptional cases. But I think if there is a case for readjusting the balance between the Section 9 stay and the Tribunal's Section 30 competens jurisdiction, revisiting the circumstances in which a case management stay might be appropriate seems a more promising avenue for development than the wholesale adoption of the prima facie standard. Now, turning to Section 67, at least for me, the same issue of principle arises to hold a party at least to a certain level of review to the conclusions of the tribunal to whose jurisdiction they may not have agreed, is, it seems to me, quite a significant thing that requires a strong justification. But the power of the court to strike out hopeless Section 67 challenges on paper, which you will see found its way into more recent editions of the Commercial Court Guide, although one will look in vain for any underpinning beyond that, and to control the evidence put in on the Section 67 process, I think provide considerable scope for controlling abuse at that stage as well. I see merit in the Law Commission's proposals that there should be an express procedural basis for those powers in the CPR. That will remove any lingering doubt as to whether those of us who publish the Commercial Court Guide really do have power to introduce controls of that kind. And I think it would act as a strong behavioural nudge to judges to exercise them. Where I part company with the Law Commission is in their attempt within the draft bill to anticipate the terms that those rules might take. I think that reduces the scope of manoeuvre for the Rules Subcommittee charged to address the point. It will make revisiting those rules in the light of practical experience more cumbersome. What I can say is we have got the message, and we hope we can be trusted to come up with a workable response without being needed to be pushed too far in that direction. One of the issues that particularly concerns me about the draft bill is the provision that evidence that was heard by the arbitral tribunal must not be reheard by the court unless the court considers it necessary in the interests of justice. That looks all set to create a number of prolonged interlocutory battles as to when that test is satisfied. There are both practical and conceptual difficulties in holding the court to the evidential record in the arbitration. As many of us will know, not every arbitration has a transcript. I know Opus 2 are present and they would offer a very persuasive response to that difficulty. But where the record of the evidence given in the arbitration is the arbitrator's notes, I wonder what you would all make of those being produced before the court. And the lawyers for the parties suggesting that wasn't quite what had been said. There's also this difficulty that when the Court of Appeal obviously adopt a review standard when considering challenges to factual findings of the first instance judge, but that is in cases in which our jurisdiction is not challenged. To apply that same approach to resolve a challenge as to whether the arbitrator had any legal power to make factual findings at all, I think takes matters a good deal further. The arbitration may have been conducted with no or limited disclosure or with attenuated time for cross-examination. And I have to say, in my experience, what generally drives the desire to refight factual issues under Section 67 is not, in fact, evidence of witnesses, but the prospect of getting more extensive disclosure from the other side for the purpose of the hearing. Now, if that's right, a rule that seeks to control abuse by saying if you could have deployed it in the arbitration, you can't, but didn't, you can't deploy it in court, is going to be of limited utility, because what people are after is what they couldn't get their hands on in the arbitration. Now, the second topic I wanted to consider, guarding the guards, the court's role in the constitution of the arbitral tribunal, whether in default appointment or when asked to remove arbitrators. Obviously, the court's appointment at the first stage only comes if the parties have not themselves, either by the arbitration agreement or by contracting into institutional rules, identified some other person who can fill the gap when they are unable to do so. The request to the court to remove an arbitrator generally come in cases where it's alleged that circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality. Now, when deciding who to appoint and deciding who to remove, I think the court is advancing the rule of law in its Bingham 7 articulation, ensuring a fair hearing for the parties. The contexts are obviously very different. Appointing an arbitrator at the outset is an essentially prospective exercise where I think the court is allowed to perhaps adopt a particular degree of caution in avoiding any problems that may emerge down the line. The second occurs very often when the arbitral process has gone some way and removal has very significant implications for that process and, let us be honest, for any arbitrator removed. And that, naturally enough, I think, requires much greater caution. In both contexts, the court benefits from the arbitrator's duty to disclose facts and circumstances known to them, which would or might reasonably lead the fair-minded and informed observer to conclude that there was a real possibility of bias. That duty currently arises as an implied term of the contract of appointment, but the Law Commission have recommended replacing it on a statutory footing, with the great benefit that it will apply regardless of the applicable law of the appointment arrangements or the arbitration agreement. Now, identifying the kinds of connection which might be capable of giving rise to justifiable doubts as to an arbitrator's impartiality has undoubtedly been immeasurably assisted by work of the International Bar Association through their guidelines on conflicts of interest in arbitration. Those were adopted in 2004, substantially updated in 2014. And the original IBA Working Party said that the guidelines were intended to be a beginning rather than the end of the process, and so it has proved. The 2014 edition identified further matters which prospective arbitrators were recommended to disclose, reflecting changes in practice and changes in expectations over the intervening years. It would, I think, be idle to suppose that best practice reached its ultimate apotheosis in 2014. I think it is changing the whole time. It will have developed over the last 9 years, and I strongly suspect we've not seen the last iteration of the guidelines. Now, against that background, I wanted to say something briefly about one continuing controversy, the issue of repeat appointments of the same arbitrator, either by the same party or by the same law firm. The IBA guidelines orange list includes the fact that the arbitrator has within the past 3 years been appointed as arbitrator on 2 or more occasions by one of the parties or an affiliate, or has within 3 years been appointed on more than 3 occasions by the same counsel or the same law firm. Those are both orange list matters. Now, we've had to grapple with repeat appointments, in particular in cases when litigation of a certain type is a regular feature of the business of one of the arbitrating parties. Insurance or reinsurance, the most obvious example, an example obvious to us all for a number of reasons. But a party who very rarely arbitrates may be represented by a law firm who very frequently does and regularly advises clients as to which arbitrator to appoint. Multiple appointments can raise concerns for a number of reasons, particularly when the appointments concern a related subject matter, with only one party or one set of lawyers privy to all the arbitration. You will know the arbitrator's duty of disclosure in those circumstances was the subject of detailed consideration in Halliburton and Chubb. That decision has generated considerable debate and criticism from some quarters, and I'm conscious the Supreme Court did not adopt the submissions made by the ICC, who intervened in the appeal. I hope you will not think me unduly timorous in those circumstances if I say no more about that. But what about repeated sequential appointments? I think these give rise to an issue of genuine difficulty. In most areas of commercial life, those who provide a good professional service expect to generate repeat customers, just as those who fail to do so will find the customer does not return. Arbitrators who are attentive to detail, conduct hearings fairly and efficiently, and promptly produce awards which are clear, cogent, and not susceptible to challenge, are providing an excellent service. It can be asked, why should they be denied the usual benefits of doing so, nor why those who've received a high quality service should be inhibited from coming back for more. Equally, where there is a right of party appointment in the arbitration agreement, it's difficult, to me at least, to see why there should be an objection to a party appointing an arbitrator who, as a matter of genuine conviction, approaches particular legal issues in a manner which happens to best suit that party's case. An arbitrator who tends to be more literalist than purposive, for example, or vice versa. I'm told that litigating parties often have regard to exactly that consideration when deciding whether to commence proceedings in the Chancery Division or the Commercial Court. But that is not, unfortunately, the whole story. I suspect most of us in this room have at some point encountered a pattern of repeat appointments of an arbitrator, where the arbitrator's appeal to the appointing party was not their commitment to their duty under Section 33 of the Arbitration Act, nor their general outlook on a topic of legal inquiry, but rather it was their expertise in sandwich making, at least to the extent of knowing which side their bread was buttered. How can that issue be tackled? Disclosure will no doubt assist. And disclosure may, at the appointment stage, when these things are much more easily addressed, provide a reason why someone who doesn't bring that complication with them may appear to be a more appropriate candidate. But at the removal stage, that there might be cases where the disclosed facts are sufficiently extreme to justify a successful 24 application, at least where the arbitrator is sufficiently guileless to lend support to it by refusing to be forthcoming in disclosure or sending hostile communications. But the reality is that successful applications of that kind are vanishingly rare. Removing an arbitrator is a very blunt tool with significant implications for the cost and duration of the arbitration. And as I've indicated, that naturally generates a great caution before any such order will be made. So an issue much better addressed at the appointment stage. It would be possible for arbitral institutions such as the ICC to adopt a rule restricting the number of appointments any arbitrator appointed to an arbitration conducted under its rules, or perhaps generally, could accept from the same party within a particular period. You see something similar in the 3 and 8 rule of the International Cotton Association, which limits the number of appointments an arbitrator can accept from the same party within a calendar year to 3, and the number of concurrent references that can be open at any one time to 8. A rule of that kind might help to broaden the pool of regularly appointed arbitrators, and in the process assist in the diversification of international arbitration, which I know the ICC is rightly so keen to promote. But of course, the problems to which party-appointed arbitrators can give rise are not limited to repeat appointments. Alan Redfern's famous survey of dissenting awards in investment treaty arbitrations found that 95% were in favour of the appointing party. Respondents to a 2021 survey found that 53% of the respondents who'd sat as arbitrators and 70% of arbitrating counsel had experience of party-appointed arbitrators trying to favour the appointing party by some means. I don't think the statistics themselves are particularly revealing. What is more revealing was that those findings were greeted with the same level of surprise as statements about the Pontus religion or the toilet habits of bears. A more radical response would be for the major arbitral institutions to consider removing the right of party appointment altogether. That innovation has a number of notable proponents, Chief Justice Menon, Professor Jan Paulsen amongst others. It's always struck me as a strange irony that parties keen to keep the dispute out of the home court of one or other of them should agree to the tribunal being constituted in part by the other party's choice, balanced only because they hope to neutralise that by a similar appointment themselves. As we ponder the means by which international arbitration can move ever closer to the ideal of the rule of law, I think the phenomenon of party appointment is something that will merit particular attention. The final topic I wanted to look at is Section 68 challenges, once again concerned with the due process element of Lord Bingham's rationalisation of the rule of law. I doubt there is any other type of court application, certainly none brought in the commercial court, with such an extraordinary high failure rate. The commercial court report for 2021 recorded that 26 applications had been brought the previous year and 4% succeeded. 9 of those were dismissed on paper. And I would just pause on that statistic for those who think we're not doing enough to root out the hopeless challenge. That is 35% not making it to a hearing, something that we're keen to maintain, or as I would put it, improve on as we go forward. One complaint which has tended to get a little more traction in Section 68 context is one that the tribunal has decided to dispute on the basis not raised by the parties. And I wanted to just look at that complaint a little more today. We're all familiar with cases in which the claimant, who has probably suffered a legal wrong, comes to arbitration thinking that that alone will get them the moon, and puts forward an extraordinarily extravagant quantification of the damage they've suffered. In the response, the respondent does not advance a rival, more realistic calculation, but limits itself to a wholesale attack on the reliability of the claimant's damage case, and argues that no damages should be awarded because the claimant has failed to put a sufficiently credible assessment before the court. Now, I suppose an arbitral tribunal in that scenario could give everything or nothing, but outside the rarefied confines of baseball salary arbitration in America, most tribunals faced with two extremes prefer to seek something closer to the actual loss in the middle. And that, in my experience, is as true of judges as it is true of arbitral tribunals. course, the arbitral tribunal could go back to the parties saying, can we have some submissions on alternative quantum calculations, please? Perhaps with a slight hint as to the direction in which both parties need to move. But I understand the tribunal's reluctance to do that. There's not only a statutory duty under Section 33 of the 1996 Act, but a professional impetus to resolve an arbitration as expeditiously as possible. And allowing a further round of argument on quantum seems calculated to inject very considerable further delay into the process. The closing of the record and the filing of the post-hearing memorial are generally and rightly regarded as a watershed moment in the arbitral process. Further, if the tribunal would then show its hand in some way by having to indicate the type of submissions that might be useful, there's a real risk of the parties or one of them adjusting their behaviour to a predicted outcome. There's also the issue of why parties who've had a chance to put forward one or more cases and not availed themselves of it should get a second shot. Lord Justice Lewison's famous description of the trial is equally applicable to the merits hearing in the arbitration. It's not a dress rehearsal. It is the first and last night of the show. Now, courts look to grant arbitral tribunals some leeway when faced with that difficulty, a room for manoeuvre accommodated within phrases such as the point being in play or the building blocks of the tribunal's approach appearing on the record, even if the precise structure thereafter erected using those building blocks was not. But there have been occasions when the tribunal's approach has been held to involve a sufficient departure from the submissions and evidence before them, and been held to give rise to a serious irregularity. Now, I have a great deal of sympathy for the arbitral tribunal here, because this is a difficult line to walk. And I think it is important for courts faced with challenges of that kind to pay appropriate regard to the reasons why the tribunal were put in the place they were put in, and the pressures of finality which they face. I recently heard a Section 68 challenge on these lines in a case called LMH and EGK. And in dismissing the challenge, I said this: it must have been obvious to the parties and wholly within their contemplation that if the case reached the question of damages, then unless the tribunal awarded either the entire amount claimed or nothing, and I cannot believe any lawyer with experience of international arbitration would have regarded either outcome as a likely scenario, then the tribunal would have to make its own adjustments or allowances to reflect LMH's attack on EJK's quantum case to the extent they were regarded as having merit. I also said that a respondent who chooses to run a scorched earth response to an overstated quantum case necessarily accepts the possibility of the tribunal fashioning something realistic from the material available to them. Now, I hope if nothing else, that decision will show how far I have come since sending my spoof emails to Toby Landau a quarter of a century ago. Now, at an event earlier this year, a member of the ICC UK board suggested to me, I think semi-seriously, that the commercial court had, if anything, become a little too pro-arbitration. As I hope will be clear, my own perspective is that the commercial court is not pro-arbitration for its own sake. To the extent to which it can be said to be pro-arbitration, it's because it's giving effect to a number of fundamental policies of English law, respecting the autonomy of individuals and legal persons to organise their affairs as they see fit, subject to minimally invasive and well-defined limits, to enforce promises which parties have made voluntarily to each other, and to favour the resolution of commercial disputes by a fair and efficient process. Supporting international arbitration serves all of those important values, and I don't think that any change in the court's approach is either likely or desirable. Now, I think it's high time that I drew to a close and return to my on-the-job training until the day comes when I can finally ascend to the ranks of international arbitrators. I shall have to content myself with administering the faint praise which it falls to the judiciary to administer when rejecting challenges to arbitral awards. so I can inform arbitral tribunals that their decision on a point of English law could not be said to be obviously wrong. And as one current Court of Appeal judge famously said when rejecting a challenge to an award of Sir Bernard Ricks, who knows, might very possibly be right. And equally, I get to say that however novel the procedure the tribunal followed is, it cannot be said to be one of those extreme cases where the tribunal has gone so wrong in its conduct of the arbitration that justice calls out for it to be corrected. Thank you very much.
Very much indeed to Mr. Justice Foxton. Really fascinating, I think, to just have a sneak peek behind the curtain of the commercial court, which is why I think that's so valuable and great guidance for us all. So thank you again. Mr. Justice Foxton will now have to leave because in a very arbitration-like timetable, he starts at 9 o'clock tomorrow morning. And so is through me passing on his apologies that he's now going to leave. But can we thank him again for that insight? And then now